I wish first to express my sincere gratitude to Professors Barzo and Silaci for inviting me to this magnificent project and to this conference. It is my great honor and pleasure to participate. Distinguished judges, dear colleagues, dear students, 4 years ago I made a short presentation of my chapter in a book titled International Law from Central European Perspective, edited by Professor, my dear colleague, Aniko Rice. And my colleague from Novi Sad, my student from Novi Sad, Ivan Jokanovic, was present, and I asked him after the presentation how did he understand my lecture, and he said, not a lot, not a lot. So, and I was not surprised. In last year, people does not understand me when I speak Serbian, and I can imagine how you can understand me when I speak English. So please do your best. I will do what I can to be clear as far as possible so that you understand me. Let me begin with a few introductory remarks that will frame our discussion. I will first outline the approach taken in this Okay. Taking this lecture and offer a working definition of fundamental rights education. I will then turn to the international normative foundation of these systems and clarify the broader purpose of our analysis. Fundamental rights education in Eastern Europe can be approached from multiple disciplinary angles. In this lecture, however, the emphasis will be placed on the European human rights law rather than on a strictly constitutional or comparative perspective. This approach reflects the legal reality in which systems of fundamental rights protection in Albania, Bosnia and Herzegovina, Georgia, Moldova, Montenegro, North Macedonia, Serbia, and Ukraine actually function. These systems do not operate in isolation. They are embedded within a broader legal framework shaped by European Convention on Human Rights and jurisprudence of the European Court of Human Rights. For the sake of simplicity, I will refer to these states collectively as the 8 countries. Although fundamental rights education is primarily governed by national constitutions and domestic legislation, it cannot be understood as a purely internal matter. It is placed at the intersection of national and international legal orders. There is also a personal dimension to this perspective, as my own academic background lies in international law rather than in constitutional or comparative law. At its most basic level, fundamental rights education may be described as the process through which disputes involving fundamental rights are resolved. Yet such a definition only partly captures its true scope. Its function goes beyond the pure settlement of disputes between parties. It also entails the active protection of fundamental rights. This dual role becomes particularly visible in disputes between private individuals. Consider, for instance, cases involving damage to reputation. Courts are not simply resolving a private conflict, but are called upon to balance the right to private life against the public interest in freedom of expression. In this sense, education transcends the immediate interest of the parties involved. Its implications extend to society as a whole. Fundamental rights education should therefore be understood as an essential and indivisible component of the broader system of human rights protection. I will now turn to International Normative Foundation of Fundamental Rights Education. States enjoy a considerable margin of discretion when designing their national systems. The European Convention does not prescribe specific judicial structures. States are not required to establish courts of appeal or constitutional courts. For example, the United Kingdom and several other European states operate without constitutional courts. Similarly, among the 8 countries, some have 3-level court system, while others have 4. These institutional choices remain within the domain of state discretion. However, this discretion has clear limits. Article 13 of the European Convention obliges all contracting parties to provide effective remedies for violation of human rights. Regardless of institutional design, states must ensure that such remedies are both available and generally effective. In this respect, the right to an effective remedy constitutes the very core of fundamental rights education. Moreover, Article 6 of the Convention requires states to establish courts by law for the determination of civil rights and obligations, as well for criminal matters. Across all systems, courts, whether ordinary or constitutional, form the backbone of fundamental rights adjudication. Importantly, all national courts must operate in accordance with principles developed through the case law of the European Court. This interpretation, the interpretation of Article 6 and 13, grounded in the principles of the rule of law, effectiveness, and legal certainty, has evolved through this jurisprudence into a coherent set of guiding principles. These principles serve as a common foundation to which all national systems must conform. The purpose of this lecture is not simply to compare institutional models or catalog their differences. Rather, it is to draw attention to potential tensions between specific national solutions on the one hand and the principles developed under the European Convention on the other. At the same time, the lecture seeks to assess the effectiveness of national systems of fundamental rights education in the 8 countries and to identify best practices that may enhance their performances. Accordingly, the lecture is structured in 2 parts. The first part will explore possible tensions between national legal arrangements and the principles derived from the European Convention. And the second part will examine the effectiveness of these systems and highlight national solutions that may contribute to stronger protection of fundamental rights. Yes. In the first part of this lecture, I will focus on dynamic and at times controversial issues, the potential tensions between principles developed by the European Court and certain national legal solutions. First, I will identify national legal solutions and practices that might be sources of tensions. Then I will refer to relevant case law presenting essence of the factual background and principles that the European Court applied in them. Consideration of compliance of particular national solutions and practices with these principles should cast some light on possible tensions between them. The national solutions we will examine concern several core aspects our judicial organization and decision-making process, including determination of territorial jurisdiction of courts, selection of constitutional court judges, dismissal of constitutional court judges, distribution of cases among judges, internal organization of courts, and judicial decision-making processes. The list is not exhaustive. Other national solutions may also come into tension with the principles developed by the court. Nevertheless, the selected issues are particularly illustrative. Most of them, apart from the dismissal of judges, relate to principles derived from Article 6, Paragraph 1 of the Convention, in conjunction with the principles of the rule of law, effectiveness, and legal settlement. The dismissal of judges, however, is primarily examined under Article 8 of the Convention. The relevant principles have been derived by the Court primarily from Article 6, Paragraph 1 of the Convention, more specifically from the phrase, a tribunal established by law. I will therefore first outline the Court's general approach to this concept. Let us begin by recalling the key provision of Article 6, Paragraph 1. And I quote, in the determination of his civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. For the purpose of this lecture, the central concept is that a tribunal established by law. A significant part of the Court's jurisprudence and many of the tensions that we will discuss come from the interpretation of these phrases. Before turning to the concrete national examples, it is therefore essential to understand how the Court approaches it. What then does the Court mean by a tribunal established by law? In the landmark case, Gudmundur Andri Astrason versus Iceland, is there anybody who speaks Icelandic language? No, then I can pronounce it this way. Okay. The Court provided an authoritative clarification of the concept. First, the notion of a tribunal implies that court must be composed of judges selected on the basis of merit. This encompasses not only professional competencies, but also moral integrity. Importantly, the Court stressed that the higher a court stands within the judicial hierarchy, the more rigorous these requirements must be. This principle is fundamental. Without judges who are both competent and ethically sound, no system of fundamental rights protection can function in meaningful way. Yet in practice, merit-based selection is often in tension with political considerations. The real challenge lies in ensuring that the professional excellence and integrity prevail over political affiliation, a challenge to which we will return later in the lecture. Second, the Court explained that the requirements that a tribunal be established by law serves as a crucial protective function. It shields the judiciary from unlawful external influence. Such influence may originate not only from the executive branch, but also from the legislature or even from the judiciary itself. The Court has further emphasized the close connection between these requirements and principles of independence and impartiality. Although the right to a tribunal established by law is formally a distinct guarantee under Article 6, Paragraph 1, it is deeply entangled with these broader principles. Taken together, these guarantees pursue a common objective, safeguarding the rule of law and preserving the separation of powers. One particularly illustrative area where tensions may arise concerns the determination of territorial jurisdiction courts. Across the 8 countries, different approaches can be observed. In some states, such as Bosnia and Herzegovina, Montenegro, North Macedonia, Serbia, and Ukraine, territorial jurisdiction is determined directly by law. In others, such as Albania and Georgia, elements of judicial organization, including territorial jurisdiction, are determined by executive or judicial bodies on the basis of statutory authorization. The divergence raises a fundamental legal question. Can courts whose jurisdiction is defined by executive or judicial bodies truly be considered established by law within the meaning of Article 6, Paragraph 1? To fully understand this issue, it is useful to recall its historical background. All 8 countries share a socialist past, and several have inherited institutional arrangements from that period, arrangements in which the executive traditionally played a stronger role in organizing the judiciary. Let us briefly consider a few examples. In Ukraine, the 2010 law on judiciary allowed the president of the state to create and abolish courts upon the recommendation of the Ministry of Justice. From the perspective of Article 6, this solution was clearly problematic. It has since been reformed, and courts are now established directly by law in Ukraine. In Moldova, courts operate within the territorial units established by parliament, acting upon proposals from the Superior Council of Magistracy. This model appears more consistent with Article 6, as the final authority remains within the legislature. In Albania, earlier legislation granted the president of the state the power to determine territorial jurisdiction. Since 2016, however, this role has largely been shifted to the Council of Ministers, who adopted the judicial map based on proposals from the common proposal from the judiciary bodies and the Ministry of Justice. In Georgia, the High Council of Justice determines both territorial jurisdiction and the number of judges. These examples reveal varying degrees of involvement of executive and judicial bodies in defining courts' territorial jurisdiction. The case law of the European Court offers important guidance in this regard. In Padzhikadze and others of Georgia, the court clarified that the concept of concept of tribunal established by law encompasses not only the legal basis for the existence of courts, but also the rules governing their jurisdiction. The case itself is particularly striking. It concerns 4 applicants from Tbilisi who were accused in 1999 for participating in a conspiracy allegedly organized by the former state security minister to overthrow the government and assassinate high-ranking officials. Beyond its political sensitivity, the case revealed how key procedural and institutional elements could be shaped by executive influence and discretionary practices rather than by clear and predictable legislation. The court emphasized 3 essential points. First, the organization of the judiciary must not be left to discretionary of executive. It must be governed by legislation adopted by Parliament and in systems based on codified law. It cannot be left to the discretion of judicial authorities either. The underlying purpose of these requirements is clear: to prevent arbitrariness, to safeguarding the rule of law. Earlier case law pointed in the same direction. In Zend versus Austria, the applicant challenged the jurisdiction of the Salzburg Labor Court, arguing that it was not a tribunal established by law because it had been created by ministerial decree rather than by legislation. In examining the admissibility of the application, the former Commission of Human Rights expressed concerns about the compatibility of such arrangements with Article 6, paragraph 1. From this perspective, national systems in which executive authorities or even judicial bodies play a decisive role in determining territorial jurisdiction may raise serious concerns under Article 6, paragraph 1, particularly where legal safeguards are weak or insufficiently precise. The second important source of potential tensions concerns the election of Constitutional Court judges. The unique position of constitutional courts within the system of separation of powers is clearly reflected in the methods used for appointing their judges. In most of the 8 countries, the appointment process is designed to involve all 3 branches of government, typically parliaments, presidents, and judicial bodies, each participate by nominating or appointing an equal number of judges. The underlying idea is to maintain institutional balance and to prevent any single branch from dominating the process. For example, in Moldova, the parliament, the president and the Superior Council of Magistracy each appoint 2 judges. In Ukraine, the parliament, Verkhovna Rada, and the Congress of Judges each appoint 6 judges. Serbia has developed a particularly complex and in many ways carefully balanced system. Parliament selects 5 judges from a list of 10 proposed by the president. The president appoints 5 judges from the list of 10 proposed by Parliament. The Supreme Court appoints 5 judges from candidates proposed by judicial councils. In Albania, an additional layer of procedural sophistication is introduced through the Justice Appointment Council, which ranks candidates. If the competent authority fails to act within the prescribed time limit, the highest ranking candidate is automatically appointed, and an interesting mechanism designed to prevent political deadlock. Other countries follow different institutional models. In Bosnia and Herzegovina, the system is particularly distinctive. Institutions of the 2 entities, the Federation of Bosnia and Herzegovina and the Republic of Srpska, appoints 6 judges, 4 Federation and 2 Republic of Srpska, while 3 judges are appointed by the President of the European Court of Human Rights, who cannot appoint nationals of Bosnia and Herzegovina. In Montenegro, Parliament elects all judges based on proposal from the President and parliamentary body. In North Macedonia, judges are selected by Parliament, with some candidates proposed by the President and Judicial Council. In principle, none of these models is inherently incompatible with Article 6, paragraph 1 of the European Convention. States retain a broad margin of discretion in designing their national frameworks. However, difficulties arise not from the design of this system, but from their application. Problems emerge when appointment procedures are used in an irregular and abusive manner, particularly where political majorities attempt to secure control over constitutional courts by influencing judicial appointments. In such circumstances, European Court may conclude that the court was not established by law, leading to a violation of Article 6. Importantly, compliance with the Convention cannot be reduced to formal adherence to domestic law. Appointment procedure must also respect the substantive principles developed in the court's case law. Irregularities typically arise when the dominant political actor seeks to install preferred candidates, thereby undermining judicial independence. A key development in this area is the three-step test established by the court in the Gudmundur Andri Arstedsson versus Iceland case. The case itself is illustrative. The applicant had been convicted of traffic offenses, and on appeal, his case was examined by a newly established court of appeal. However, one of the judges sitting on the panel had been appointed through a procedure previously found to involve irregularities. The applicant challenged the composition of the court, arguing that it was not established by law. His objections were dismissed at the national level, and his conviction was ultimately upheld by the Supreme Court. In response, the European Court developed a structured three-step test to determine whether irregularities in judicial appointments amount to a violation of Article 6. First step is manifest breach of domestic law. There must be generally a clear violation of national legal rules governing judicial appointments. However, the court has made it clear that even in the absence of such a breach, a violation may still arise if the outcome contradicts the very purpose of the right to tribunal established by law. This point is crucial. Formal compliance alone is not sufficient. Second step is violation of fundamental rules. The irregularity must concern fundamental aspects of appointment process. Minor or purely technical irregularities will not suffice. The decisive question is whether the irregularity undermines judicial independence, the rule of law, or the separation of powers. And third step is lack of effective review and remedies. There must be no adequate domestic mechanism capable of reviewing and remedying the irregularity. National courts are expected to engage with these issues in light of the Convention and the Court's jurisprudence. When these three conditions are met, the Court will find that there is a breach of Article 6. Another highly relevant case is Xeroflora versus Poland. In this case, the applicant company sought constitutional review of legal provisions affecting compensation. However, the Constitutional Court discontinued the proceedings without addressing the merits. Crucially, the panel included a judge whose appointment had been widely contested as unconstitutional. He had been appointed to a seat that had already been filled. This raised a fundamental question. Could the Constitutional Court in such composition still be regarded as a tribunal established by law? The European Court answered this question by emphasizing that the process of appointing of judges is not a peripheral issue. It is an integral part of the very concept of a tribunal established by law and must therefore be subject to strict scrutiny. The Court further clarified that the notion of law encompasses not only formal legality but also the quality of law. Rules governing judicial appointments must be clear, precise, and predictable. They must not permit arbitrary interference by political authorities. Ultimately, the central issue is one of legitimacy, whether the illegality is sufficiently serious to undermine the independence and credibility of the court itself. Third source of potential tensions lies in national provisions and practices concerning the dismissal and premature termination of the mandates of constitutional court judges. Across the 8 countries, the rules governing dismissal vary significantly. In Albania, Bosnia and Herzegovina, Georgia, Moldova, and Ukraine, judges may be dismissed on the grounds of professional or ethical misconduct. While this may appear reasonable, such broadly framed grounds can raise concerns regarding legal certainty and feasibility. By contrast, in Montenegro and Serbia, dismissal is typically linked to a criminal conviction for offense that render a judge unfit to perform judicial functions, a more narrowly defined and arguably more predictable standard. There are also important institutional differences regarding who decided on dismissal. In some countries, constitutional courts themselves decide on dismissal of their members. In others, such as Montenegro and Serbia, this power is vested in parliament. The European Court has addressed this issue in its case, most notably as Ovcharenko and Kolos versus Ukraine. This case concerned the dismissal of 2 judges of the Constitutional Court of Ukraine. Under the Constitution, judges could be dismissed by a breach of oath. However, the concept was not clearly defined in domestic law. The context of the case is highly revealing. The dismissed judges have participated in the decision declaring unconstitutional certain constitutional amendments that shifted the balance of power toward parliament. After some time, parliament dismissed them on a ground of breach of oath. The European Court found that this dismissal violated the judge's right to respect for private life under Article 8 of the Convention, which encompasses, among other things, professional reputation. The Court emphasized several key principles, and interference with this right must have a clear legal basis. The applicable law must be sufficiently precise and foreseeable. Vague and undefined concepts such as a breach of oath allow excessive discretion and create a risk of arbitrary application. Because the legal framework lacked the necessary clarity and safeguard, the Court concluded that the dismissal was incompatible with the requirements of legal foreseeability. The fourth source of potential tensions concerns national provisions governing the distribution of cases and the internal organization of courts. These issues fall directly within the scope of Article 6, Paragraph 1 of the Convention. The requirement of a tribunal established by law also implies the right to a lawfully appointed judge. In practical terms, this means that judges cannot be selected arbitrarily to hear particular cases. Accordingly, rules governing the allocation of cases must be clear, precise, and sufficiently detailed to eliminate any risk or even appearance of manipulation. The 8 countries apply a variety of methods for distributing cases. In Albania, cases are assigned to report judges by lot under the authority of the President of the Constitutional Court. In Bosnia and Herzegovina, cases are generally assigned in alphabetic order. However, the President of the Court may depart from this rule, and absence of clearly defined conditions for such deviation raises concerns about legal certainty. In Georgia, cases are first allocated to chambers or the plenary by the President of the Court, after which an electronic system assigns a reporter judge. Nevertheless, court leadership retains a degree of discretion. In North Macedonia, the President of the Court assigns cases typically on the basis of internal rules rather than automatic systems. In Montenegro and Serbia, electronic systems are used for automatic case allocation. However, the President of the Court may reassign cases on the grounds for such, and the grounds for such reassignment are not always clearly defined. In Ukraine, cases are assigned according to alphabetic order. These examples reveal a common pattern, a combination of automatic mechanisms such as electronic allocation or alphabetic order and discretionary powers, most often exercised by court presidents. The European Court addressed this issue in DMD group versus Slovakia, a case that illustrates the risk associated with discretionary case allocation. The facts are particularly instructive. Initially, cases at the district court were allocated according to pre-established work schedule, with all enforcement cases assigned to a single section under Judge C. However, after Judge D became court president, the work schedule was amended and to distribute enforcement cases across several sections, including his own. On this basis, the applicant's case was reassigned to Judge D through a specific degree. This reassignment formally relied on changes to the work schedule and took place within a broader redistribution of hundreds of cases. The applicant argued, however, that the frequent amendments to the schedule enabled the potential arbitrariness, especially since Judge D decided the case on the very same day it was reassigned to him. In its judgment, the European Court emphasized several key requirements. Rules governing case allocation must provide strong guarantees of objectivity and transparency. They must be sufficiently clear to prevent arbitrariness. They must exclude any perception that cases are assigned in a manner capable of influencing their outcome. The court also observed that court presidents, when organizing the work of court, may act in an administrative capacity linked to the state. This increases the need for particularly strict safeguards. The fifth area of potential tensions concerns national provisions governing the decision-making process in constitutional courts. Here again, notable differences can be observed across the 8 countries. In Albania, Bosnia and Herzegovina, Montenegro, and Serbia, decisions generally require a majority of all judges. In Georgia, Moldova, and Ukraine, a majority of judges present is sufficient. in North Macedonia, qualified two-thirds majority is required in certain cases. Some systems allow abstentions, while others do not. These variations are not in themselves problematic. Institutional diversity is both expected and permissible. However, difficulties arise when procedural rules prevent courts from reaching a final determination of a case. The European Court has constantly emphasized that Article 6 guarantees not only access to a court, but also the right to a final determination of a dispute. The tied vote or lack of majority does not automatically constitute a violation. However, if such a situation results in the absence of a decision, either on the merits or admissibility, this may lead to breach of Article 6. A leading example is Marini versus Albania. In this case, the Constitutional Court failed to reach the required majority. As a result, it did not adopt a final decision, and the applicant was left with the possibility of submitting the claim. So it was previous solution in Albania that if Constitutional Court face tied vote or for any other reason there is no decision, the applicant can resubmit his claim later, and Constitutional Court can consider the same matter later, hoping that it will reach majority. The European Court found that that the applicant had been left without a final determination in violation of the right of access to a court. It stressed that the legal systems must contain mechanisms ensuring that a final decision can always be reached, even in situations involving a tied vote. Another important case is Avdic and others versus Bosnia and Herzegovina. Here, the Constitutional Court formally adopted a decision, but failed to serve a required majority of votes on the key issues. So at the moment, the court was not complete. There was, I think, 6 judges. Majority was 5, and judges were divided 4-2. So there was no 5 judges, and because of that, there was no decision. So Constitutional Court formally adopted a decision, but failed to secure a required majority of votes on the key issue. As a result, the judgment contained conflicting reasoning, reflecting both majority and minority views, without actually resolving the applicant's claim. The European Court clarified an essential point: merely formal decision is not sufficient. What is required is genuinely a determination of the dispute. Without this, the right to access the court becomes illusory. Further development in this line of reasoning can be seen in Meli and others versus Albania. In that case, the Constitutional Court rejected complaints because it failed to reach the required majority. Although the decision was formally final, in the meantime, Albania changed its law, and even in the case of tied votes, the decision has become final. So this decision was final. But it did not resolve the case because there was no proper majority. So there was no reasoning explaining why the complaints had been dismissed. This absence of reasoning raised serious concerns regarding transparency and fairness. The importance of reasoned decisions is further illustrated by Paun Jovanovic versus Serbia. In this case, the Constitutional Court rejected the applicant's constitutional complaint on procedural grounds, stating that it did not concern an individual act or action of a state authority, a prerequisite of admissibility. As you know, in countries which allow constitutional complaint, it is one of procedural requirements that this complaint refers to individual act of state organ or individual action. And Constitutional Court of Serbia found here that this complaint did not refer to an individual act of state organ. It was an order of an investigative judge. But the Constitutional Court did not explain why it did not consider an order of investigative judge as an individual act of state. Neither explanation was in its previous decisions. So, So the court failed to explain why an order issued by investigative judge did not qualify as an individual act, and the European Court therefore found a violation of Article 6, paragraph 1, emphasizing that the absence of sufficient reasoning deprived the applicant of meaningful understanding of the decision. A recent decision is not just a mere formality. It demonstrates, says the court, to the parties that their arguments have been generally considered and contributes to the legitimacy and acceptance of judicial decisions. From these cases, the European Court has articulated several key principles. Article 6 includes the right to a final and reasoned judgment. Courts must provide sufficient reasoning to enable both the parties and the public to understand the decision. A lack of reasoning undermines transparency and public confidence in the judiciary. Qualified majority requirements may also raise concerns. The court has accepted that such requirements are not inherently incompatible with Article 6. However, problems arise when they make it excessively difficult to obtain a decision in favor of the applicant or operate in combination with other factors such as vacancies on the bench, which further reduce the likelihood of reaching a required majority. In such situations, the effectiveness of judicial protection may be seriously compromised. An additional dimension of concern relates to the finality of judicial decisions. The principle of res judicata is cornerstone of legal certainty. The European Court examined the principle in Gaba versus Albania. The facts of the case reveal a complex procedural history. A district court judgment in 2003 recognized the applicant's father as the owner of a piece of land. The judgment became final in 2004. In 2006, a restitution authority restored the land to the applicant. This decision has become final, and the applicant took possession. In 2009, the state advocate initiated proceedings to review the case, leading to the annulment of 2006 decision. The domestic court adopted conflicting approaches. The Court of Appeal emphasized the importance of legal certainty, while the Supreme Court later concluded that the decision had never been final. The applicant's constitutional complaints was ultimately dismissed. The European Court reiterated several fundamental principles. The right to a fair trial under Article 6 includes the principle of legal certainty. Once a decision has become final, it should not be reopened merely to allow a different outcome. A review procedure must not serve as an excused appeal. Reconsideration is permissible only in exceptional circumstances, such as serious errors or manifest injustice. The second part of this lecture shifts the focus from identifying tensions to evaluating performance. It addresses the effectiveness of fundamental rights education and the identification of best practices. I will begin by clarifying what is meant by effectiveness in this context and by proposing a simple method for measuring it. I will then apply this method to 8 countries in order to highlight the impact of one particularly important institutional mechanism, the constitutional complaint, on the overall effectiveness of national systems. Building on this analysis, I will attempt to identify best practices, that is, specific national solutions that appear to enhance the effectiveness of fundamental rights education. In doing so, I will examine practices relating to following issues: appointment of constitutional judges, length of mandate and rules of reappointment, powers of the President of Constitutional Court, appointment of legal advisors, referrals by ordinary courts, direct effect and primacy of the European Convention, interpretation of constitution by constitutional courts, and execution of constitutional court decisions. This aim is not merely descriptive, but evaluative, to understand which institutions' choices contribute the stronger and more effective protection of fundamental rights. By effectiveness of fundamental rights adjudication, I refer to the capacity of national system to produce adequate legal outcomes within a reasonable time. These outcomes must be consistent with the principles derived from the European Convention. The effectiveness of the 8 national systems is far from uniform. In order to assess this, I propose a simple, though not uncontroversial, method of measurement. Effectiveness is inversely proportional, according to my mind, to the number of cases per capita brought before the European Court. In practical terms, a higher number of cases suggests lower effectiveness of the national system. A lower number indicates higher effectiveness. The logic behind this approach is straightforward. Individuals turn to the European Court when they consider that national authorities, particularly courts, have failed to prevent or remedy violation of their rights. Using this method, I aggregate all cases from each of the 8 countries over the period 2015-2024 and divide them by the average population during that period. The results, expressed as a number of cases per 100,000 inhabitants, are as follows. Moldova, 373, Ukraine, 280, Georgia, 255, average 225, Serbia 204, Bosnia and Herzegovina 193, North Macedonia 170, Montenegro 169, Albania 162. This allows us to distinguish between 2 groups: relatively more effective systems below or near the average, Albania, Montenegro, North Macedonia, Bosnia and Herzegovina, Serbia, and relatively less effective systems above the average, Georgia, Ukraine, Moldova. The differences are significant. The gap between Serbia, 204, the least effective within the first group, and Georgia, 255, the most effective within the second group, is important when viewed in relative terms. Of course, this method is open to criticism. One might argue that the number of cases depends not only on dissatisfaction with domestic system, but also on other factors such as public awareness of human rights, familiarity with European system, access to legal assistance. While these factors do play a role, their impact should not be overstated. For example, for comparison, the United Kingdom recorded only 2.4 cases per 100,000 inhabitants. Please note, not 240, not 24, but 2.4 cases per 100,000 inhabitants during the same period. This suggests that the higher awareness and better access to legal assistance do not necessarily lead to more cases. Quite the opposite. They often coincide with a more effective domestic protection. An important factor that may help explain the difference between the 2 groups is the existence of constitutional complaint. All 8 countries provide for constitutional review of normative general acts. However, only Albania, Bosnia and Herzegovina, Montenegro, North Macedonia, and Serbia allow for constitutional review of individual acts, including co-decisions, upon request by individuals. These mechanisms enables individuals to challenge concrete violations of their right and at the constitutional level. The significance of the constitutional complaint should not be underestimated. There is a fundamental difference between abstract review of legislation and review of individual acts. In cases involving individual acts, the factual context becomes decisive. Courts must balance competing rights and interests. Decisions frequently require an assessment of the principle of proportionality. These are precisely the types of issues that the European Court addresses on a regular basis. For these reasons, constitutional complaint procedures function as a kind of domestic filter. They allow national courts to resolve human rights issues before they reach the European level, thereby reducing the number of cases to the European Court. Although the Convention does not oblige states to introduce constitutional complaints, their existence clearly enhances the effectiveness of national systems. Another important development is the adoption of Protocol 16 to the European Convention of Human Rights in 2013. This instrument allows the highest national courts to request advisory opinions from the European Court of questions concerning the interpretation of the Convention. All 8 countries, except Serbia, have ratified this protocol, and Ukraine has already made use of this mechanism. This tool has the potential to significantly strengthen the effectiveness of national system by improving the quality of judicial reasoning, ensuring closer alignment with the Convention's principles, and preventing violation before they occur. Despite these positive developments, the gap between the 8 countries and more developed systems remains striking. As I said, the United Kingdom has only 2.4 cases by 100,000 inhabitants, and best performing country among the 8, Albania, has 162. This comparison highlights a scale of the challenge. The central task of the 8 countries is therefore clear: to strengthen their systems of fundamental rights education so that effective protection is ensured at the national level, thereby reducing the need for individuals to seek justice before the European Court. Now, we are now turned to best practices. Progress in strengthening system of fundamental rights education does not require entirely new solutions. It can often be achieved by drawing on institutional models that have already proven effective in practice. A comparative view across the 8 countries reveals several such examples. First relates to appointment of constitutional court judges. Certain institutional mechanisms can play a decisive role in reducing political deadlock and reinforcing judicial independence. I mentioned already in Albania, the Justice Appointments Council complies and ranks a list of candidates. If the competent authority fails to make an appointment within a prescribed time limit, the highest ranking candidate is automatically appointed. This mechanism is particularly valuable. It prevents institutional paralysis and limits the space of political bargaining. Its importance becomes even more apparent in systems requiring qualified parliamentary majorities in appointment constitutional judges, such as Montenegro, where appointments may otherwise be blocked, leading to prolonged negotiations and increased politicization. In Ukraine, an additional safeguard is provided by the advisory group of experts, which evaluates candidates' professional competencies and moral integrity. Its mixed composition bringing together representatives of state institutions and civil society helps ensure the merit prevails over political consideration. This model enhances both the credibility and quality of judicial appointments. Following relates to length of mandate and reappointment. The duration of judicial mandates and the possibility of reappointment are crucial factors affecting judicial independence. Several countries, including Albania, Ukraine, North Macedonia, and Georgia, provide for a long non-renewable mandates. This is widely regarded as best practice, as it shields judges from external pressures and allows them to decide cases without concern for their future position. By contrast, systems that allow reappointment, such as those in Serbia and Moldova, may create initiatives for judges, incentives for judges to consider how their decision could affect their prospects of renewal. From the perspective of judicial independence, non-renewable mandates are clearly preferable. Powers of presidents next is related to powers of presidents of constitutional courts. Although the core functions of court presidents are broadly similar, important differences exist in the scope of their powers, particularly with regard to convening court session and setting the agenda. In Bosnia and Herzegovina, these powers are not concentrated exclusively in the hands of the president. Sessions must be convened when requested by a judge. Judges may propose amendments to agenda and request removal of the case. This model effectively limits the concentration of power and reduces the risk of internal influence over judicial proceedings. It can therefore be regarded as a best practice. By contrast, in systems where the president exercises exclusively control over scheduling, especially in absence of a clear time limits, there is a risk of indirect influence over the timing and potentially the outcome of decisions. These concerns has been observed, for example, in Serbia. Appointment of legal advisors. Legal advisors play a vital role in supporting the work of Constitutional Court, particularly in complex fundamental rights cases. Different institutional models can be identified. In Albania, legal advisors are appointed and supervised by the president of the court. In Bosnia and Herzegovina and Serbia, they are appointed by the court as a whole, in plenary. The latter approach is generally preferable as it reduces hierarchical dependence and strengthens institutional autonomy. In addition, practices that encourage international professional exchange, such as those existing in Serbia, where legal advisors may work with international human rights bodies or foreign constitutional courts, represent a particularly valuable form of good practices. Such exchanges enhance professional expertise and contributes to the overall effectiveness and quality of judicial decision making. Referrals by ordinary courts. The legal systems of the 8 countries generally empower ordinary courts to refer questions concerning the constitutionality of normative acts to constitutional courts. Such referrals typically arise when an ordinary court encounters a constitutional issue in pending case, either raised by the parties or identified by the judge ex officio. In this way, constitutional adjudication becomes directly connected with real disputes rather than remaining purely abstract. However, the structure of this mechanism varies across jurisdictions. In Bosnia and Herzegovina, the Constitution of Federation authorizes the Supreme Court, the Human Rights Court, and cantonal courts to submit such referrals. In North Macedonia, referrals are permitted only where the Constitutional Court cannot be directly, only when the Constitution cannot be directly applied in the case. In Moldova, following the decision number 2 of 9 February 2016, a broader approach has been decision of Constitutional Court. I will say something a few minutes later about this decision. A broader approach has been adopted. The Supreme Court, appellate courts, and district court may refer constitutional questions both ex officio and at the request of litigant. Instead, they are obliged to do so when such a request is made. In Ukraine, by contrast, this power is centralized. Only the Supreme Court may refer constitutional issue. In Montenegro, the process includes an additional procedural step. A judge or panel chair must notify the president of the court, who then informs the president of the Supreme Court about the referral. Among these models, the Macedonian solution appears particularly promising. By allowing ordinary courts to apply the constitutional directly where appropriate, it partially decentralizes constitutional review and enhances the efficiency of fundamental rights adjudication. Direct effect and primacy of the European Convention, the direct effect of the European Convention with the domestic legal systems and its primacy over national law plays a crucial role in ensuring the effectiveness of fundamental rights adjudication. While the 8 countries regulate this issue in broadly similar ways, important differences remain. In Albania, ratified international treaties are directly applicable and prevail over ordinary legislation. A similar approach is found in Bosnia and Herzegovina, where the convention is directly applicable and takes precedence over statutory law. In Georgia, international agreements prevail over domestic normative acts, except when they conflict with the Constitution. In Moldova, priority is given to international human rights treaties in cases of conflict with domestic legislation. Montenegro adopts one of the most robust models. International agreements form an integral part of the domestic legal order, have a supremacy over national legislation, and are directly applicable whenever they regulate a matter differently. It should be also emphasized that according to jurisprudence of the European Court, the Convention may take precedence even over constitutional provisions. This position was clearly articulated in Sejdic and Vinci versus Bosnia and Herzegovina, and some other cases. In practical terms, this means that the case law of the European Convention should play a central role in guiding constitutional courts and interpreting national constitutions. Montenegrin model, in particular, stands out as a best practice by allowing a direct application of international agreements. In cases of conflict with domestic law, it effectively decentralizes constitutional review and contributes to a more responsive and efficient system of rights protection. I need some time to learn how to use this. The next issue is interpretation of the Constitution by Constitutional Court. The manner in which constitutional courts interpret the Constitution can significantly influence the effectiveness of fundamental rights education. A particularly illustrative example is the interpretation of Article 135 of the Constitution of Moldova by its Constitutional Court in 2016. This provision, which defines the powers of the court, Constitutional Court, states that the court solves petitions of unconstitutionality of legal acts as submitted by the Supreme Court of Justice. However, the Constitutional Court adopted a broader, purposive interpretation. It held that not only the Supreme Court, but also appellate courts and district courts could refer constitutional issues, especially when raised by litigants. In human rights adjudication, the European Court itself is well known for, by litigants. This interpretation marks a clear departure from the strictly textual reading. Yet such an approach, departing for strictly textual reading, might be, according to my opinion, wishful and expected in fundamental rights education. The European Court itself is well known to its evaluative method of interpretation, guided by the object and purpose of the Convention, as well by the underlying principles such as the rule of law, effectiveness, and legal certainty. The impact of this interpretive shift in Moldova was immediate and significant. In 2015, it means a year before this interpretation, only 59 complaints were submitted to the Constitutional Court, of which just 3 were referrals from the Supreme Court. In 2017, it was a year after this interpretation, the number has increased to 176, including 137 referrals from ordinary courts. This demonstrates how a single interpretation, a single interpretive move can dramatically enhance access to constitutional justice and strengthen the overall system of fundamental rights protection. Another notable example is the Constitutional Court of Bosnia and Herzegovina, which has been characterized by a high degree of judicial activism. It has played a transformative role in shaping the country's constitutional order, moving it from a loosely structured arrangement under the Dayton Constitution toward a more functional state. One of its most significant decisions upheld the constitutionality of the law on the court of Bosnia and Herzegovina, enacted by the High Representative, despite the absence of an explicit constitutional basis for such court in the Constitution. This illustrates how constitutional interpretation can actually contribute to institutional development. Execution of constitutional court decisions, the effectiveness of constitutional adjudication does not end with the adoption of a decision. It depends equally on the execution. Different legal systems provide different mechanisms to ensure enforcement. In Georgia, a designed judge who performs a function of secretary of the court, it is possible for monitoring execution and reporting regularly to the court. In Montenegro, execution is explicitly required from a wide range of public authorities. In Bosnia and Herzegovina and North Macedonia, any interested party may initiate proceedings to secure execution. In Moldova, Parliament plays a direct role, particularly where legislative amendments are required. A particularly strong solution can be found in North Macedonia. There, the Constitutional Court may formally establish that a decision has not been executed and notify the public prosecutor. This mechanism introduces an additional layer of accountability. It can be regarded as a clear example of the best practice. So I came now to concluding remarks. The two key conclusions emerge from this analysis. First, all those states enjoy broad margin of discretion in designing their systems of fundamental rights adjudication. All elements of these systems, institutions, procedures, and practices must comply with the principles developed by the European Code, particularly under Article 6 and 13 of the Convention, in the light of overarching principles of the rule of law, effectiveness, and legal certainty. Second, even where systems are formally compliant, their effectiveness may vary considerably. Enhancing the effectiveness is therefore an ongoing process requiring continuous institutional refinement and reform. One of the most practical and achievable ways to improve performance is through the adoption of best practices identified in comparable legal systems. Despite notable progress, a significant gap remains between the 8 countries and more developed systems in Western Europe. Bridging this gap will require sustained efforts, above all strengthening judicial independence, improving procedural safeguards, and ensuring that the fundamental rights are effectively protected at the national level. Thank you very much for your attention, and I hope that you understand something of my